Recording in progress.
Good morning, members. Good morning, DM. Good morning, colleagues.
Good morning.
Yes, the chairperson has requested that we start the meeting at 9:10.
Okay, agreed.
Okay, thank you.
Noted, thank you.
Okay.
Morning, sir.
Nearby, just a quick one. This warning letter,
Yes, sir.
I see it's dated 23rd of April.
Yes, that is.
Sorry. Can you mute your discussion, please? Thank you. Good morning, everyone.
Good morning.
Morning, Chair. Good morning, Chair.
Morning.
Yes, Chair, it's 9:10, and we have got enough members to start the meeting, and the stakeholders are in the meeting also.
Okay, thanks very much, Mr. Matonzi. Good morning, honorable members. Morning, Deputy Minister. Deputy Minister and all members of the panel, the Parliamentary Legal Services, the Chief State Advisor, the legal team of the Department of Home Affairs led by Advocate Malekate, and all stakeholders in attendance. Members, we are going to deal with 4 items that are before this meeting, and I must appreciate that we have on Tuesday dealt with the one-stop border post bill in terms of deliberations, other matters that were before the committee. We agreed that this meeting will then adopt, because we said they must go back and work on just to clean up where there were errors in terms of the drafting of the document. And today's meeting is just going to adopt clause by clause, adopt the report. And I must also appreciate the discussions that ensued around this subject matter for over a period of time in the portfolio committee. I must appreciate also the members of the committee who deliberated on the candidates of the Independent Electoral Commission and the decisions that were taken in that meeting on Tuesday. And further appreciate the work that has been done in yesterday's report around the 2024 national and provincial elections. Members of the committee and other members in the House engaged on the report, and all the recommendations that were proposed were carried, arising from your deliberation as members of the committee. I'm informed that the minister is outside the country. He can able to join us at 9:45 to introduce the panel, And the issues around the reports of the panel. We've been receiving a lot of correspondence because that we had some of the issues, agenda items in the committee meeting. We could not deal with this matter. We've scheduled it for today. We'll outline how we've understood the submission of the report and give the opportunity to the minister to interface with the committee. I will invite Honorable Mr. Matonsi to, if there's any apology, and formally on record introduce, indicate who is in the meeting so that when we invite them on the particular items, we are clearer on the issues.
Yes, Chairperson, from my side, I've got an apology from Ms. Ngoveni, so she's not going to be able to attend. And then just also to indicate, Chairperson, I've seen that the minister has joined the meeting, although he's overseas, he has joined the meeting now, he's in the meeting at the moment, Chair. From the stakeholders that I have been invited is the department, which is here, led by the minister, and then also including the Electoral Reform Consultation panel, they are here. And then I also see that the IEC is in attendance as well. And then the legal advisor from Parliament and the department, they are here as well, especially for the one-stop border post. Sure. That's all.
Okay, thank you. Can I establish if the advocate Suzanne and the team, as well, advocate Suzanne? Okay. Any member who's representing the panel?
Yes, I'm present, Chairperson. Good morning, Chairperson and members. We are present. It's Richard Sizani. Thank you.
Thank you, advocate. The legal team?
Good morning, Chair. The Parliamentary Legal Services is in attendance.
Thank you. Legal team, Department of Home Affairs? Okay, Chief Legal Advisor? Okay. Now that they're not here, how are we going to deal with the second item?
Chairperson, I think I saw Moses in the meeting, unless if he has got difficulties in. But at the same time, the Parliament Legal Advisor will go through the areas that they have corrected, and then we can just do close by close. But I saw Moses in the meeting as well. I didn't see the state law advice.
Okay, were they informed or invited to the meeting?
Yeah.
Okay. Thanks very much. Can we proceed, Mr. Mshopo, on the item number 3?
Good morning once again, Honorable Chair. Good morning, honorable members and colleagues. I'm just waiting for the B bill to be flighted on screen. Go down a bit, Mr. Matonze, on the cover. There we go. On the cover page, on Tuesday, there were areas that have been identified for correction. Mostly they were typos and others that were not identified. We just had to go through the B bill in its totality to make sure that everything is in order. On the cover page, where it said as proposed by the portfolio committee, it was replaced by as amended by the portfolio committee. So that change has been effected. And then on page 2, line 9, up, Mr. Matonzi.
Yeah.
Line 9. Yes, where it says 6 movement. On page 2, line 9, we deleted free transfer of money of goods within common control zone and replaced it with a movement of goods of money within common control zone for official purposes. And then on page 4, line 21, line 21 up, Mr. Mutonze. We just deleted the inverted commas. And then on page 4, line 29, after the words being made and, so those two words appropriate in inventories. It was one word in the beginning, and we had to separate those two words. So that change has been effected. And then on page 4, line 35, we deleted the inverted comma there. And then on page 7, item 336, clause 6 deals with the movement of goods or money within the common control zone for official purposes. So those were the changes that were effected on the B bill. That brings us to the end of the corrections that were made. Thank you, Chair. Thanks, honorable members.
Thanks, honorable members. And thanks for correction. So this B bill arises from the A list. We have deliberated on this matter, and members, you requested the legal team to go and effect those corrections to reflect the status of your contributions in the meeting. Well, now I will invite that to proceed by clause to consider adoption, so that we also adopt the report of the one-stop border post. You can proceed, Mr. Mashoko.
Yes, clause 1 deals with the definitions. In this act, unless the context shows that another meaning is intended, adjoining state means a neighboring state, including the agency of the state with whom an agreement has been entered into. An agreement means an international agreement referred under in section 3, subsection 1 of this act, and concluded in terms of section 231 of the Constitution. Border law enforcement means the execution and enforcement of relevant legislation relating to legitimate facilitation of movement of persons and goods within the border law enforcement area and ports of entry. Common control zone means an area established in terms of section 3.1 of this act, where the domestic laws of the Republic and adjoining state in respect of border controls apply, and where officials of both states apply their respective domestic laws. Constitution means the Constitution of the Republic of South Africa, 1996. Exclusive zone means an area within the common control zone dedicated for the exclusive use by officials of the Republic or the adjoining state. Minister, we mean the Minister of Home Affairs. Official means an authorized person responsible for exercising border controls on behalf of any organ of state, and includes a police officer. One-stop border post means a port of entry designated as a one-stop border post in terms of section 3.1a of this act. Port of entry means a port of entry designated by the minister in terms of section 9, capital A of the Immigration Act of 2002, which is Act number 13 of 2002, and includes any port, point, or place of entry or exit approved by the minister in terms of section 30 of the Border Management Authority Act 2020. That is Act 2 of 2020. The Republic means the Republic of South Africa. Next page. Regulation means any regulation made under this act, and this act includes the regulations. The application of the act, that is clause 2, this act applies outside the territory of the Republic in accordance with any international agreement entered into between the Republic and another state in terms of section 231 of the Constitution. Clause 3 deals with the establishment of one-stop border post and common control zones. 3, subsection 1, subject to Section 231 of the Constitution, the minister may conclude an agreement with any state to A, at any port of entry, establish a one-stop border post to be jointly managed by the Republic and the adjoining state. B, within the one-stop border post, designate a common control zone. And C, authorize officials of both states to exercise, Roman figure 1, border law enforcement at the one-stop border post contemplated in paragraph A, or any power to arrest, search, seize, or detain any person or thing in accordance with the laws of the Republic. 3.2. The minister must establish one-stop border posts to publish by notice in the Gazette a list of one-stop border posts contemplated under Section 1A and common control zones contemplated under Section 1B. Clause 4 deals with the application of border law enforcement. 4.1, the agreement contemplated under Section 3.1 may, subject to the domestic laws of the respective states during the negotiating of an agreement, take the following into consideration insofar as the laws relating to border law enforcement are applicable. A, the laws of the adjoining state apply in the common control zone established in the territory of the Republic and must be enforced by the officials of the adjoining state in the same way as they are enforced in the territory of the adjoining state. And B, the laws of the Republic may apply in common control zone established in the territory of the adjoining state and must be enforced by the officials of the Republic in the same way as they are enforced within the Republic. 4.2, any contravention of laws relating to border law enforcement of the adjoining state within the common control zone in the territory of the Republic is subject to the laws of the adjoining state as if the contravention occurred in the territory of the adjoining state. 4.3, let's go up a bit, Mr. Matonzi. Mr. Matonzi, let's go up a bit. 3. Yes, any contravention of the laws relating to border law enforcement of the Republic within the common control zone in the territory of the adjoining state is subject to the laws of the Republic as if the contravention occurred in the territory of the Republic. 4, an official enforcing border law enforcement and procedures in a common control zone must do so in accordance with the border law enforcement laws of the state that he or she works for. Clause 5 deals with the application of criminal laws. 5.1, subject to subsection 5, and the process in any article of extradition or mutual legal assistance agreement entered between the adjoining state and the Republic of South Africa, where an act or omission that constitutes a criminal offense in an adjoining state is committed in the common control zone in the territory of the adjoining state. A, the offender consent is subject to the jurisdiction of the courts of the adjoining state, and B, the offense is decided in terms of the criminal law of the adjoining state. 2, where an act or omission that constitutes a criminal offense in the Republic is committed in the common control zone in the territory of the Republic, the offender consent is subject to the jurisdiction of the courts of the Republic, and the offense is decided in terms of the criminal law of the Republic. 3, where an act or omission that constitutes a criminal offense in the Republic is committed in the exclusive zone of the Republic in the territory of the adjoining state, the offender consent is subject to the jurisdiction of the courts of the Republic, and the offense is decided in terms of the criminal law of the Republic. 4, where an act or omission that constitutes a criminal offense in the adjoining state is committed in the exclusive zone of the adjoining state in the territory of the Republic, A, the offender consent is subject to the jurisdiction of the courts of the adjoining state, and B, the offense is decided in terms of the criminal law of the adjoining state. 5, despite subsection 1, where an act or omission referred to in subsection 4 is also an offense in the Republic and is committed A, in the common control zone in the territory of the Republic, and B, by a person who is not a citizen of the adjoining state, and the laws of the adjoining states apply to the extent that a finding of guilt of that act or omission may lead to the offender being imposed a death penalty. The offender consent is subject to the jurisdiction of the courts of the Republic, and the offense is decided in terms of the criminal law of the Republic. Clause 6, that's the one that was amended. The words in brackets have to be removed and the ones that are underlined have to be inserted into the clause. So the clause will read, movement of goods or money within the control or the common control zone for official purpose. Subject to the agreement envisaged under Section 3, goods or money moved by an official for an official use or for an official purpose from the territory of the Republic or the territory of an adjoining state to the territory of the adjoining state or republic, as the case may be, within the common control zone are not subject to entry or exit, import or export laws of the republic of the adjoining state. Subject to proper declarations being made and appropriate inventories being kept, all equipment which is necessary to enable an official of the republic or adjoining state to carry out his or her official functions in the control zone must be freely transferable within the control zone. For purposes of this section, official purpose means an act done in the execution or performance of a function, power, or duty conferred by any law of the Republic or an adjoining state. Clause 7 deals with the obligation to readmit. Where the state of entry, either the Republic or the adjoining state, declines to admit any person, vehicle, animal, merchandise, or other goods, a person illegally enters the Republic or the adjoining state at any place other than through a designated port or entry of the Republic, or the state of entry, either the Republic or the adjoining state, refuses entry of any vehicle, animal, merchandise, or other goods. The state where such a person, vehicle, animal, merchandise, or other goods arrived from must readmit such person, vehicle, animal, merchandise, or other goods into its territory. 2, despite subsection 1, the competent authorities of the state of exit, when receiving such a person, may take any measures in accordance with its domestic laws that does not impose obligations of the state of entry. Clause 8 deals with the regulations, that the minister may make regulations regarding the terms and conditions relating to the use of the one-stop border post or common control zone, and generally any other ancillary or incidental administrative or procedural process that is necessary to prescribe for the proper implementation of the administration of this Act. The short title of this Act is called the One-Stop Border Post Act of 2024 and comes into operation on a fixed date by the President by proclamation in the Gazette. That is the clause by clause takes us to the end of the B bill. Thank you very much, Honorable Chair and Honorable Members.
Thank you very much, members. Can we now consider the clause by clause? Honorable Ross.
Thank you, Chair. I'm happy with the changes. I'd like to move for adoption.
Thank you very much. Seconder?
I second, Chair. Okay.
So Honorable Mtolo seconded. Any other contrary view, objection on the process that was undertaken in all the clauses that were outlined by Mr. Mshoko? Mr. Matonzi?
Yes, Chair, you want me to go through the report? I don't see any other hand.
Yeah, so this, it will mean that you will present the report and the reflection of the proposed amendment that were submitted before the committee and all the public hearing that we have invited members for oral submissions. Deliberations were carried by members who debated around this matter, and the A-list was presented before the committee. We then dealt with the all the clauses, and this is a big bill that has been finalized, and all of us, we agree in terms of the issues that we referred them back for Parliamentary Legal Services, the Chief State Law Advisor, and the legal team of the Home Affairs. You recall that we did also invite SARS to deal with the clause 6 on issues that were concerned raised by the committee and also the legal team. So thank you very much. We'll now request a report to be adopted, and once it's been carried, it will then be referred to the National Assembly for report and for Assembly to consider the bill, and then to be referred to the President for assent. Thank you, Mr. Matonsi. You can now proceed.
Yes, Chairperson, this is the report of the Portfolio Committee on Home Affairs on the One-Stop Border Post Bill, B12 2024, dated 24 October 2025. The Portfolio Committee on Home Affairs, the committee having considered the subject of One-Stop Border Post Bill B12 2024, referred to it and classify it by the joint taking mechanism as a Section 75 bill, reports the bill with amendments, that is B12A 2024. And then introduction. On 11 September 2024, the Minister of Home Affairs introduced the One-Stop Border Post Bill, B12 2024. The bill in Parliament, it was subsequently referred to the committee for consideration and report. The bill, as introduced, broadly seeks to regulate the establishment of one-stop border posts through the international agreements, provide for the establishment of common control zone in the territory of the adjoining state, provide for one-stop border post processing arrangements, authorize the application of the laws of the Republic and the adjoining state in one-stop border post, and provide for matters connected with herewith. Then number 2, parliamentary process. On 5 November 2024, the Minister of Home Affairs and the department briefed the committee on the contents of the One-Stop Border Post Bill. The bill was advertised on the Parliament website and social media platforms from 6 December 2024 in the print media in all official languages during January 2025 to invite public comments. The closing date for the submission was 28 February 2025. The committee received 8 written submission. The content advisor briefed the committee on the summary of the submission on 20 May 2025, and public hearings were held on 27 May 2025. The following organization and individual were invited to and participated in the public hearing on 27 May 2025. Scalabrin Center and Southern African Bishops Conference, the Consumer Council of South Africa, the Congress of South Africa, the South African Trade Union, the Office of the High Commission for Human Rights, the Lawyers for Human Rights, Lawyer for Human Rights, and the individual is Tatos Leke. On 10 June 2025, the committee adopted a motion of desirability, MOD, and deliberated on the One-Stop Border Post Bill. Subsequent on 22 July, the Department of Home Affairs, together with the Parliamentary Legal Service, responded to the submission received and the issues raised during the public hearings on the bill. The committee further deliberated on the bill on 3 September, instructed Parliamentary Legal Services and the State Law Advisor and the Department of Home Affairs to finalize the A list of amendments. Then, prior to the meeting scheduled for 16 September, at which the committee was expected to adopt the A list, the committee received a letter from the South African Revenue Services and the Financial Intelligence Center regarding clause 6 of the bill. The correspondent raised concern about the provision allowing officials to move money and goods between South Africa and the adjoining state for official purposes. Concerning the matters raised by SARS and FIG, the committee deferred the adoption of the A-list to allow the department and relevant stakeholders to address the issues. The A-list was subsequently finalized and adopted on 10 October. The clause-by-clause deliberation, as well as the adoption of the bill, just to change it, and the adoption of the bill and the bill itself took place on the 24th, which is today, October 2024. Reports to be considered. That's all, Chair.
Thank you very much, Mr. Matonzi. Members, this report that reflect our deliberations in the committee, I will now invite the members to consider. Any hand mover for adoption?
Thank you, Chairperson. I'm moving for the adoption. We're happy with the changes and it seems as if they did exactly what we were expected to do. Thank you.
Thank you, Honorable Machi. Mover for adoption, seconder. Honorable Ross, I see your hand.
Chair, I second the adoption of the report.
Thank you. Any other contrary view? Thank you very much. The report has now been carried and the bill has been carried. It will be now be ATC and be forwarded to the Parliament. Thank you very much, Mr. Matonzi and the team, and thanks the Parliamentary Legal Services, the Chief State Law Advisor, the team that is led by the Minister from the legal team of Home Affairs, and yourselves, honorable members, for having considered, deliberated in a decision that will now be taken to the National Assembly for consideration. I will now move to the third item on the Electoral Reform Consultation panel. Let me start with the areas that led us to this and what it has been always the view carried by the committee and the development that has now been exposed to us as the committee and the guidance that we need to, so that when the minister comes in and the team, they understand clearly where we think we must assist, because this is an important piece of a report once a legislation is being carried by Parliament and it has been initiated by members of the public during when we're dealing with the electoral amendment bill in the consultation and also in the discussions that the committee carried and also in the National Council of Provinces. So Minister Mutwaledi at that time in the sixth administration, as a result of the Constitutional Court judgment, appointed a team led by former Minister Valimusa and the team, and was presented before the committee, and that was approved to assist the Parliament and the department on the areas of the legislation that we may need to consider, given that the Constitutional Court has taken a decision. So that team worked very well. They then managed to develop a single report with options as a collective presented to the Minister for Home Affairs then. And the Minister presented the report to Parliament or to the Speaker and referred to this Committee of Home Affairs. And we then received a detailed brief from the team that was led by that time, and the Minister gave us an opportunity, or members of the committee, to deal with that. We then subjected that report, because a decision can't be taken by a committee once it can be taken by the committee because members of the public ought to input further in terms of shaping a legislation that Parliament may need to consider. So we subjected that report to members of the committee, and also the public conducted public hearings. The different views were carried, and we came, deliberated, and then moved to Parliament and the NCOP to consider the bill, Electoral Act, with the changes that we thought was important to deal with. Subsequently, we considered, given the views expressed and the submissions made by stakeholders, political parties, individuals, that we may need to consider to look on the current electoral system or the existing system, but we need a team or a body that may need to evaluate and assess, consult, and also bring a comprehensive report to the minister, and the minister then bring a report to table the report to Parliament, to the Speaker, and refer it to the committee. And the team that was appointed was, we then requested the minister to go and advertise in relation to inform by the decision of the committee and the provisions that are entailed in the Electoral Act. Advertised for person to be nominated, a collective of citizens who can assist to look on this issue that was resolved by Parliament. That was done. The minister brought the first list to the committee, and the committee dealt with this issue, and we referred the names back to the minister. And I think you can recall that there was a point, there was a second advert in the consideration of persons or individual who must assist us. Minister Mjolid came back to the committee and we agreed and adopted the names that must be presented to Parliament. And Parliament approved for the appointment of the team, the collective that is led by Advocate Richard Sizane, to facilitate, consult on the electoral system and examine the current electoral system. So I'm moving from this background so that we do understand that the responsibility that is carried, it's a collective work that all of us ought to be accountable and responsible when we discharge. So in other words, that the chairperson of the Committee of Home Affairs, they can't do any other thing or any other member of the committee without a framework of a process of a collective decision that should be presented to the committee, to Parliament. We deliberate, we differ on other issues, and at the end, there must be a collective decision that is owned up that will assist us to move forward. So, Minister, I'm raising these matters because it will appear that we have received letters that were written to the chair and to the committee in relation to the process that was undertaken. And I must first appreciate the team that is led by Advocate Sizane, that they've consulted stakeholders, contributed to the paper, the process that was undertaken to enrich the documents ultimately for a purpose of making a proposed areas that the Parliament or a citizen may need to comment on. It may appear that at the last stage of the process that was undertaken, and it's evident on the letters that we've been receiving from the panel, and we don't want to get into majority or minority reports and differently. I'm advised in terms of the letters that were sent that the challenges on how the final report was consolidated to your attention. And that will make this meeting so difficult to allow the report to be presented to this meeting, because we want, and we're not disputing the details or the content of those reports, because we've not taken a decision nor interacted with yourself and able to brief the committee. We must understand that part, the process that was undertaken in terms of the report that was tabled before the minister and within the time frame that was allocated. And I wanted to raise these matters to you, the minister and the team and the members of the committee, so that you ought to understand that a report that was supposed to have presented before you, it should be a collective report with the views that I expressed, different views or different options that members of the committee may want. But it was important that a minister received a report. In other words, a minister has been put in a corner, and also the committee, to deal with the challenges that could have been dealt with by these collective experts and who have experience in the fields that we've occasioned them to interact with. And I think we must say, deal with that part so that there's a credibility in terms of the process that was undertaken by a collective, so that when the committee interact with this matter and also subject it to the public hearing, there's clarity on the details and avoid litigations or complaints on this and the other. There are members of the community or individuals who have written contesting some of the issues that are raised in the draft proposal. And we have not arrived at that point where we are inviting members of the public, individuals, to comment on the issues that are arising in that point. This report should be subjected thoroughly to consultation, written submissions on all the issues that have been raised by that time. So we've advised that at the point that we're going to develop a program of action to interact with this matter, how we're going to interface with the demarcation board, interface with the public participation throughout the country, interact with the stakeholders, oral submission and written. We're going to work on that with the legal team of Parliament. We have then requested the legal team of Parliament. I have requested them to look on these challenges that are arising from this report, so that we avoid to subject Parliament to court challenges on the issues that will be taken to the discussion of Parliament. So we're raising this matter of concern, Minister, that it will appear that there are two reports that have been presented separately. It will appear that there's a report that was submitted outside the collective of your team that you have appointed. And I'm referring to you that you have now appointed through Parliament, and the costs that are apportioned to the work that has been dealt with by members of the panel. And we must appreciate the team and yourself, Minister, and the Director General, for making sure that this team is able to make it easier for functioning of the portfolio. I'm trying to draw attention, Minister, that it may appear that you ought to consider to convene the panel to interact with these two reports that have been presented separately. I may not know the reason, but I think you are best to account to the committee and also assist the committee to get out of this challenge before we interact with the detailed presentation. And I'm fully aware that even the time that is allocated for the team to present full brief is shorter, and members may need to get, or the team on yourself, time to detail the report of the panel. I will put the recommendation that we ought to step off this item until these matters, yourself, the minister, and the team resolve them, and have a consolidated report that is submitted to your attention. Will request the speaker, present to the speaker the challenges that you are facing on your behalf. And our position is that we may need to have a clean and guided process that should be able to assist all of us, because this is an important matter the country may need to interface with. And the work that has gone into through a committee led by Advocate and the collective it's important. So it can't be spoiled by challenges administrative that we can manage. I'll leave it at that point, Minister, and invite you and also allow members to comment if there are issues of guidance before we can allow the team. We must avoid to deal with these challenges as members of the committee panel may express them in this meeting, but will allow you, Minister, and able to give you time to deal with these matters and then reconvene the panel fully with yourself to present a comprehensive a report with all the options or differences that are there. But we can't afford to start with the challenges that we could have avoided and resolved at the first point. Minister?
Good morning, Chair. Let me just check if I'm audible first. Can you just confirm?
Yes, proceed, Minister, audible.
Thank you very much, Chair and honorable members, colleagues, senior officials. It's good to join you this morning. Thank you for the opportunity to make a contribution on this particular item. Chair, I think you have correctly identified the background to how this issue came about, flowing indirectly from a constitutional court judgment. And then my understanding is that the portfolio committee itself was proposing the creation of this panel in the previous administration, as you've said, to comprehensively consider these electoral reform options. So, Chair, let me just say, firstly, in terms of your comments, that this is an inherited panel. It is not a panel that I personally appointed. It was appointed by the Minister of Home Affairs, and so it was already in place by the time that the 7th administration came into office. And so that process was then inherited. And if you look at the legislation, the actual Amendment Act that came into force, it was clear that that Parliament, this committee, wanted an independent process to assess options for possible electoral reform. And so it is in the spirit of that independence that the ministry and the department conducted itself during this process. There were secretarial support services offered by the department, as well as, of course, the financial implications were covered by the department, but it was a completely independent process. My own engagement with it was limited to the engagement at the public conference that we had, which I believe, Chair, you and DM and others certainly also participated in, as well as one request for an extension of 3 months that was granted. Now, Chair, I'm emphasizing and raising this point because we have to be very mindful of not contradicting or complicating the call or the substance of this amendment, which was about this independent panel and the consideration of possible options. So it is with that in mind and that clear legal mandate from this committee and from Parliament that I think once the documents were received, including the covering letter from the chairperson, it was very clear that there's no role for the minister to intervene, influence, or in any way direct the substance of what the panel was working on or proposing. And I think it's very clear, Chair, why that was the case, that we don't want to defeat the purpose of this panel, which is to, as you've said, bring those public considerations into full view. Now, of course, the entire process was based on public consultation, so I'm not sure if I'm not sure if we are moving forward, if that's an exercise that now needs to be repeated, if I understood your comments correctly. But I would be somewhat hesitant about that, given that we've just gone through a very thorough and expensive public consultation process. It is that consultation process that led to the creation of the documents that were then tabled with myself. As you've correctly said, Chair, there were two versions of this report that were submitted, as well as the covering letter from the chairperson, Advocate Sizani. Now, again, Chair, if you look at the legislation, and this is certainly what we did at the time, given that we understood it was certainly less than optimal that we have two documents that are actually submitted containing different views, we consulted the legislation to say, what is the legal mandate? Is there a way that the minister can assist to resolve this? But the advice there is very clear that because this is an independent process, one initiated by Parliament through this legislation, where the minister is a facilitator, not a decision maker, that there was no scope whatsoever legally for the minister to interfere at that particular point to either take a view on the correctness or not of any of these documents or the positions that they advance, as well as on the process. This is a process that is the responsibility of the panel, of the chairperson and the members of this panel. As I said to you, there is at no stage was the minister involved in any of these processes substantively, and it would be incorrect to then kind of not give the minister the responsibility to manage the process, but at the end of the day say that that I must fix the outcome of it. That's not going to be, I think, even from a legal perspective, something that we can take forward, because this is an independent process. I think the other important point, Chair, is that if you look at the legislation, the minister's role is to table and cause to be published this report publicly within 30 days. And that was very clearly prescribed by the committee and Parliament when you as members came up with this particular process. And certainly from my perspective, we have complied with that. The process, we facilitated the process of the report. And once the documents were received, I fully and transparently made that available to the Speaker as well as to the NCOP chairperson, and we caused it to be published. It's available online, and I'm sure members have had a look at some of these documents. Now, that is the role of the minister. So now we are functus officio in legal terms. There is no scope whatsoever for the minister or anyone else to convene this panel or to direct this panel or to in some way cause the substance of the panel's work to be influenced, changed, or redirected. The other point that is worth noting, Chair, and I think we've got to collectively decide on the way forward, as you've said, but we have to then take into account as well what this legal amendment says. A key provision of the amendment is the fact that it actually provides for disagreements. It provides for the possibility of disputes. Now, I don't know the extent to which the committee would have deliberated on that possibility when you enacted this legislation, but I get the sense clearly that it was foreseen that there would be disagreements. And I think that is clearly what we are dealing with here, that there are substantive disagreements among different members of the panel, but there is no provision in the legislation around what constitutes, something that can be excluded or not, whether it's one person's view or the panel's entire view. And actually, the advice and the sense that we got when looking at those provisions in the legislation was that because Parliament provided for the possibility of disagreements, my sense is it would be very difficult to tell anyone to not or to exclude any of the submissions that have been made. So it seems to turn at some level on the question of whether this is one document, whether it's two documents, whether it's one report. But I think from a substantive legal point of view, Chair, the sense is that there are options before the committee. I would also submit that the ministry has fulfilled its role, it has facilitated this process, and it is indeed functus officio from a legal perspective. And the real question that faces us, certainly as you've correctly said, Chair, is to understand what happened in this process, and that is an answer that can only come from the panel. It is not something the minister can be held to account for. It's not something the minister can answer, because the minister was explicitly not made part of this process. So the chair and the panel must answer for themselves and describe the issues that they disagree on. But I think the fundamental point is, even if that is done, even if the disputes or disagreements are processed and aired before this committee, the fundamental question is what happens next. At some point, a decision has to be made, and it's a decision based on a number of options that have been sort of tabled here, and that, I think, is the substantive point that we will have to somehow get to, Chair. So what I am very much willing to say is that you have our commitment on supporting, in whatever way we can, that process of now sort of taking this into a decision space, and I'm very much open to the committee's views. Is that a white paper process? Is it legislation? What is the process that would be appropriate now? But I'm just cautioning, Chair, that we mustn't taint the process at the very end now, which was very much designed to be hands-off and independent from any politician, frankly, from sort of guiding or directing that process. So what I would, in summary and in conclusion, Chair, apologies, it's been a few minutes, but you can see we've been dealing with this issue. Just to conclude.
Proceed, Minister, don't rush. Proceed.
Sure. Just to sort of give you my sense of what may be a way forward, but certainly I think the committee must deliberate this issue thoroughly, would be to allow the panel, and again, if we take the transparency and the independence of the panel as the motivating force, that was the idea, I think, of the legislation. To allow them to say, what is it that they disagree on? Why do they disagree about it? What is the process that led to this disagreement, and why they could not actually make our life easier, Chair? If there was one report with all of the different views, I think we wouldn't be losing more time on this fundamental issue. We would actually be able to get to the substance. But the reality is all of our lives have been complicated because of what appears. And I must emphasize, it's only an appearance based on what I've seen in terms of the letter, that there was a lack of communication to be able to say, I take this view, you take that view. Let's just clearly articulate in the panel that the following members take this view on this model and the other members take the following view. And I think it is deeply unfortunate that that did not happen. I think it is needlessly complicating the life of the committee and of members. But I do think, and this is really the only substantive issue that I tried to resolve before tabling it, is what other options are there? And really the conclusion from my side is, well, the question remains the same. There are options that have been presented in two documents, and at some point we as members have to decide how we take it forward. So, Chair, I think that's probably the best I can do at this point. It is not the ideal outcome for any of us, but I do just want to caution that none of us should, I don't think it's correct for the minister to now sort of go and, in some way, even because there are two documents, try and find some kind of middle ground or influence the outcome, because we do want an independent assessment. And we got that. Certainly different views, different opinions have been provided to the committee. And perhaps the more substantive question, after you as members have engaged with the panel to understand the process and the issues, is how would we take it forward? What would be the appropriate next step? And I think certainly from our side, we are very much willing to engage on that. We'll give it some thought and work collaboratively with the committee to undo some of the unfortunate outcomes here, but most importantly, to actually find a way forward that works for everyone. Thank you very much, Honourable Chairperson and members.
Thank you very much, Minister, for the comment. And I think if you have understood our comment, was that we're not apportioning a blame on the ministry. we have outlined details on the functioning of the committee and also the independence work that should have been done by the panel that have been appointed by Parliament. And I think you must stay it easy that we are not apportioning that. I've indicated that the minister and the committee has been put on the corner given the development around the submission. Secondly, we have highly indicated that the team has done substantial work in relation to the consultation and consolidation of views throughout members of the public and stakeholders, and the support that was apportioned to make it easy for the committee independently to do that. And this is not the first panel that we've been interacting with. We've interacted with the panel that is led by former Minister Valumusa, and Minister Aaron Mzwaledi and yourself as minister did not interfere on the processing of the bill, and that is not an expectation in terms of the framework of the legislation. Hence, even ourselves, members of the committee, we do not interfere with the work of or influence the processing of the bill or the report. What all of us were concerned, I think, at your end, Minister, you articulated clearly that challenges that you have identified. And I think we must appreciate that compliance in terms of processing the reports, table them within the bill, approving the extension, and for consideration of Parliament is where we are now because of that process. But it is important that the committee and Parliament, the work that we deal with arising from the team that was being appointed by Parliament is able to be guided and clear, so that when we interface with this subject matter, where all the matters that were supposed to guide the panel has been detailed. I'm going to invite Advocate Suzanne and members to comment on the matters that I've raised and the minister have raised in terms of the cautioning on the process that is ending. And we must be clear, all of us, that we are not disputing the content of the report, but the process that will the collective process that has not been satisfied by the panel. I'll invite members or let me invite Advocate Suzanne first, or let me get members to guide if we can deal with this matter first before we invite the members of the panel. Honorable Mokhale and Honorable Ross.
Thank you very much, Chair, and greetings to honorable members. Chair, I want to ask firstly, the report that is going to be presented to us, is it the minority report or is it a majority report? Because, like you have indicated, Chair, and I agree entirely with your sentiments, we want one report that consolidates all the views that have been canvassed from the public, so that we deal with one report. Because this thing of two different reports, a minority report and a majority report, I don't know, maybe it can create problems. Because what if we agree with what is presented as a minority report? What if we agree with that report? And what are the implications thereof? So I would really maybe propose that we stay off these two reports, this report, Chair, that this committee, they go and consolidate this into one single report that they will then present to the committee. Because we have given this committee a lot of time, Chair, and it's quite unfortunate that we are at this stage. with regards to what is happening amongst them. So I would really say, Chair, that let's not go into the report that is before us. Let them go and consolidate whatever reports that are there into one single report that will then be able to deal with. Thank you, Chair.
Thank you, Honorable Mohale. Honorable Roos.
Thank you, Chair. Chair, I think it's very unfortunate again, the position that we as a committee are being put in. I think you're being quite kind, Chair, because this committee is constantly being put in a position where we're being delayed. The electoral system we have now is because we were almost strong-armed into taking a minimalist option for the sake of time, because things dragged on the last time around to such an extent with the MAC report, what their proposal was, then the time it took for the ministry to then produce the bill. So the ministry is also waiting now for guidance. So, we're supposed to have this report, debate it and give some guidance. And then to my understanding, the ministry develops the draft legislation. And then we are in a position to look at it as a committee. And it also puts the IEC in a position where they must rush to implement before elections. Because if any process now takes another 3 months or whatever it may be, and then it goes into next year because we've gone over now the end of the year, they will be the ones, the IEC will be the ones that are criticized when the cracks show. When we say there needs to be a certain system, a constituency system, and then there needs to be a demarcation, and then by the time they get it, they need to implement systems changes. They're going to be the ones that are going to be criticized. And we as a committee are going to be the ones that are criticized for not processing the legislation fast enough. So this needs to end, Chairperson. There is no provision for the panel to not present the report in the required format because it wasn't envisaged clearly. I mean, the minister's role is to appoint professionals of the highest caliber, persons with experience and stature that can produce this kind of a report. And the functions are clear. 23.2a, the functions of the panel are to independently investigate, consult on and report on and make recommendations in respect of potential reforms of the electoral system for the national and provincial legislatures. And then the law says that the report contemplated must reflect the views of the members of the panel. So it must reflect the views of the members. It says the report, one report, must reflect the views of the members of the panel. Members of the panels, all members of the panel, as to the possible options and recommendations. And then in 23.5b, it says, in the case of a disagreement as to the possible options and recommendations for electoral reform, the report may be divided into different sections setting out the different views of the members. So, Chair, I don't know how one can really look at this and get confused. There's one report required, and if there are disagreements, then there's different sections in that one report that say what the disagreements are and sets out the different views. And then that report is now delivered. And then, Chair, on receipt of the report, the minister's role is purely to, within 30 days, table the report to Parliament for consideration and publish it electronically. So again, Chair, there's no provision. We sit here now as a committee where there's no provision for the fact that the panel has refused to deliver what they were mandated to do. They've delivered 2 separate reports under the names of different members. Neither of the reports reflects the view of all the members as required in the legislation. And so now we're in a position where we're delayed, Chair. We need to have a report that prescribes with this law because this is what's in the law. We need to implement the legislation of the land and act according to the law that we passed. So Chair, we either need a combined report or we need some legal mind to tell us that these 2 reports do indeed constitute a single report or feedback. And then we can say, well, we've been advised that these 2 documents, we take them as one report, even though they're in 2 documents. and then we process them. But Chair, the ministry is waiting now. You know, 2316, it says the minister must dissolve the panel after the report is tabled. And once the minister and parliament no longer require the panel to perform any of its functions. But there's also a matter of expense, Chair, because this panel has taken its 12 months and then it took an additional 3 months where expenses are incurred. Now the panel has not delivered what it was supposed to deliver, a single document with the views of everybody, disagreements or other views put in different sections of the document. And so my view, Chair, is that the panel must put this together at their own expense, that we shouldn't have to bear the expense of that. But Chair, we do need some advice on this as well in terms of what the legal process is, what the reasonable time frame is, because the challenge we have again is that if we're told it's going to take 3 to 6 months for something which shouldn't take that long, it takes us into next year. It disturbs us. So I think we need to understand: can we take these 2 reports as one, or these 2 documents? And then, second of all, Chair, we have to understand what the differences were and what caused them. That needs to be very clear, Chair. I would like to understand what they are and why they were so onerous, or why they were so strong that we are not able to sit here today and receive these 2 reports. So, Chair, to my understanding, these should be considered as one report, and the various parties should present what they need to present. So, if we need a legal opinion on that, to meet in a few days. But yeah, it just seems to me that first of all, we need an explanation of why this panel has not delivered on a very simple mandate. And then secondly, how we can resolve this as quickly as possible, because we can't afford 3 or 6 months. So we should get that confirmation that we can accept these 2 reports as one. Is it legally permissible? And then the persons that are here and have taken the time should present their views on why there was the disagreement. Thank you, Chair.
Thank you, Honorable Roos. Honorable Nguban.
Yeah, thank you very much, Chair, for the presentation. I think, Chair, in South Africa, we need to start taking people of South Africa serious and prioritize them and stop these egos that sometimes mess up good things that we're trying to do for our good people. So, Chair, our opinion reports in contradictions to each other or in total different views that can be consolidated? That's the first question. And the second one, is there a way we can benefit without looking at a deadlock panel from both of these report? Why this difference was not resolved before it even come and reach us? Couldn't the panel sit and then find a way to consolidate and create one report that in that report has all these different views of them, so that when we come here, we read one report that have these contradictions inside? Will there be no comeback to us on this issue of a panel that is not in unison in their views? If we don't want to be hindered, Chair, from doing our work once we receive this report. Hence, I take your view seriously that we need a legal opinion on this matter, so that we know how to move forward, taking into consideration the views that we're going to receive. This mainly is and has been the duty, Chair, of the chairperson of the panel to unite this team. Why hasn't this been done so by the leader of the panel? By this virtue, Chair, it again give us all the same sentiments, Chair, that always been said, that in South Africa sometimes we lack leadership that is highly decisive on critical matters of divergence, and where people have to show their skills of how to implement conflict management mechanisms, but they totally sometimes dismally failed us. These people in the panel are people of high stature who have led on many occasions, who are highly experienced in leadership and in conflict resolution mechanisms. It's so confusing. How can we as a committee be put in this quagmire by such respected people? But yeah, I think somehow we need to find a way to, if we can benefit, to find out that are the differing views in contradictions of each other of same point. Maybe there is different in the same point that the other one goes east and the other one goes west, or else is it total different views on the matter at all that is not in contradiction to an other, that can be consolidated in one views in the document. If we can find out that, Chair, because really, you hear members, we are worried. We have shortcomings there in the IEC, and we have people who are supposed to assist us in fixing these things, but they are adding more salt on the wound again. And then tomorrow, when we blame the IEC on its shortcomings, it will be the contribution of this panel that's supposed to assist us in this reform that we want in the IEC. I think that's my input, Jay. It's a pity we are being put in this quagmire by such respected people. We need to get a better way forward to make sure that we stick to deadlines and we make sure that we don't compromise the IEC in the next critical work that it must do in the 2026 local government elections. Thank you, Chair.
No, thanks, members, for your contributions and guidance on how we must proceed on this subject matter. I will invite Advocate Suzanne as the chair of the committee of the panel to comment, and then we guide on how we are going to deal with this matter. If any other member of the committee or the panel want to comment, once the chairs comment, I will allow any other member of the panel, but already a guidance has been grounded. Thanks, Advocate.
Thank you very much, Chairperson, for giving me this opportunity. Chairperson, am I audible?
Yes, you're audible, Advocate. Proceed.
Yeah, yes, let me take this opportunity to say, I'm talking a little bit in doubt whether I'm still the full chairperson of the 9-member panel, but I will take this opportunity to lead in terms of the honor that I've been given by the chairperson.
Okay, let's clarify that so that you understand the state. The minister has not yet considered to dissolve the panel.
Yes. Oh, thank you very much.
And you have not yet presented a brief report to the committee.
Okay.
So yes. So proceed within that.
No, thanks. So I accept that, Chairperson. Chairperson, let me just say, I am fully helped and supported by your comments as you have made them quite clearly. I am fully in agreement again as part of the panel with what Minister Dr. Schreiber said about what has happened. Mr. Chairperson, I will not take the time of this committee, as you said quite correctly, that to give details about the differences and the workings of the panel. But what I just want to point out is just a few things to the panel. That members of the panel, we worked together as a team for 15 months. And I am not going to blame any panelists or mention any names of panelists or whatever, but I am going to say throughout that period, we did work collectively, putting collective views, building up chapters, and our full report, which we all wanted to be consolidated, was going to be about 7 pages. The important thing that the panel must bear in mind is that in those 7 chapters that we had, is that especially chapter 2 on the franchise, chapter 3 on basically other commissions that have worked on this work, the full research on chapter 4 on principles of assessing legal systems and so on, or electoral systems and so on. And chapter 5, which was also a very critical one, which our chairperson himself had said, go to every corner to listen to South Africans, to various sectors, and get an opinion. Chapter 5 deals with those inputs. So our recommendations were supposed to be chapter 6, and then we will close. Chairperson, throughout our discussion as we move as a committee, there was basically some substantial disagreements on each chapter, chapter 3, chapter 4, chapter 5, even and so on, about how things should be interpreted and what things were heard in the hearings, what research has come up to, and what positions particular members did. Unfortunately for ourselves, it became quite clear, as you see, that there are 2 reports, that there is a team which is pushing a particular view and program that is about 5. There are other people who are saying that there are certain things we have heard, there are certain things that we have listened in the research that should come up through. So 2 weeks before we finalize the final report, which we're working together with 4 members of the team that is panelists that are 5, then circulated what they said is a redrafted report now. When we were left to discuss, and the time had run out only with chapter 6 of the recommendation, but built up on everything else. When some of us ask, but what is this process? There was even an attempt to say it was approved by me. I had no power to approve such a process. So basically what happened is that these colleagues did rewrite, re-edit, remove a number of things that were part of the inputs of the collective. When we even ask together as to what are even these changes that have been made, but what kind of a process, because we had all agreed that we have somebody, Professor Ndletyana, who's appointed to draft, and we all make inputs to him. What we had heard separately was a team where there are differences between 1 and 2 people or others, where those people could then meet and discuss and find solution. So, Mr. Chairperson, what I'm trying to emphasize is that on that last week, going towards delivering the report on the 29th, we then had this report drafted by these 4 colleagues who are part of the 5 colleagues who have come out without involving any of the other colleagues that they might have disagreed with in terms of inputs in dealing with that, without the entire panel agreeing about that, and without us even openly telling us what are the track changes. That is why you will find, Mr. Chairperson, in the report that we call it the original, that was the report that was not yet was not amended, was being built up by all of us. We indicated to the committee that this, in chapter 2, these things are edited. In chapter 3, these things are edited, and we're doing this ourselves. In chapter 4, these things are edited. In chapter 5, these things are edited. And in chapter 6, certain things are said and so on, which are not part of our understanding. So then that is why when we met on the 18th of August, which was our last month, we then said, there's this problem that is facing us now that there is an alternative report and which we don't know, and it has not been explained to us. And we have this report, which we have been working together, disagreeing and agreeing and compromising, but moving ahead. And we've had chapters. We are now on chapter 6, which is the final chapter on recommendations. What then bothered the 4 people who were not included at all, including the chairperson, was the fact that the chapters before, unfortunately, build up to the kinds of recommendation you'll be making to the committee. If then a number of colleagues just remove those things that are the building blocks, by the time you reach chapter 6, there will be no understanding as to why yourselves are making this report and why they themselves are making their own things, because they have unilaterally cut out a number of things. We have sent that list to Parliament together with our presentation as the team of 4. And therefore, Chairperson, the issue now was, what is foreseen by the honorable member from the TA who's saying here of us making comments? This is what we had seen, because we're not making a decision on this matter. It was our belief that basically we would be able then, if there's 1 colleague or 2 colleagues who disagree about a particular thing, then we can comply and put it there. So we read in context the entire legislation, and we find in section 22, subsection 3, that we must actually produce a report that will enable members of the committee to actually carry out its constitutional duty to find a system that they can choose based on these things. So what therefore was necessary, that we agreed together, both sides, we agreed that we are so far apart, and the way that this thing has been done now, that to try and force up issues, what basically would happen is that in your consolidated report, as you suggest now, would be basically 1 chapter 1 and 1 chapter 2, and with highlights of the differences, 1 chapter 2, 1 chapter 3, and so on until we reach the recommendations. We said, in order to make this thing easy so that Parliament can see, even their researchers and their own teams can see, okay, because we're advanced with our report, we've not yet finished. They are also advanced with their report. They have not finished certain things. Let's give Parliament, in the best interest of ensuring that they understand what are the differences, and that the differences are not only on recommendations, they are actually on the research that is deleted. They are on public hearings that are not our case, that are amended unilaterally, and set to remove certain things that people had said, which is what Parliament has sent us to listen to people. There are certain things that are inserted basically without any now evidence base as was required. So we wanted you to see, and that's what we have done, that the portfolio committee to see that this is what is cut. And the implications for this is that it undermines any resolution, for instance, from our side, that would either suggest a particular reform because of it. And if it's not there in chapter 2, it's not there in chapter 3, and again, the public hearings which were recorded, and which had reports, if they are now can be amended and just said these just such as views of ordinary people and just things like that, and we can easily ignore them, then we disagree about what impact we can put on that, because we felt we should tell Parliament, whether they are happy or not, what the people out there said about the systems and so on. So what the benefit the Parliament has is actually a report that is amending certain things and basically not showing other things, and a report that is called the original report, which gave basically a dispassionate view of all the things and the research and the things that we had, and then based on that gave some recommendations that are not different. But that was still within the spirit of the legislation in our understanding. I'm not, Mr. Chairperson, giving a legal opinion. It's up to Parliament to do that. It was to allow Parliament, and we've, for instance, assisted ourselves by saying, here are what we see are the fundamental differences. Here are the things that were amended by these colleagues 2 weeks before we close, after 13 months of working together. And therefore, Mr. Chairperson, we have no option but to give you 2 reports and show Parliament where are the differences. And we feel that within that spirit, even Parliament and its researchers or whatever can be able to see, because as Minister Schreiber quite correctly say, there are clear recommendations on both sides and arguments for those things that Parliament can easily put them together and deal with them and understand without anything. But I will not stand in front of Parliament, because this is something they send us, and ourselves as the panelists are saying, this is what we got. Unfortunately, we interpreted it differently almost throughout, and therefore bringing us together to try and put it. The only thing that can help is again to put all our views together as they were, because we had full reasons for 15 months why we put them. So our view, Chairperson, is that we've done everything possible. That's why I said in my letter, to try and ensure that we have one report, and with some of those views that might be divergent from one member or another. But unfortunately, chapters have been amended. Chapters have been cut. Other things have been added, we don't know. 2 weeks before the final thing, at the end of the day, we've seen that they do undermine recommendations we would have made from some of us, and therefore we felt obliged to say we would want to put before Parliament what we had from the people. Because, Mr. Chairperson, as we went out, all the people without respect, without difference in all the areas of the 9 provinces, as the Chairperson said, we must go to rural areas and urban areas. There was a complete negative vibe from people that we're just doing a ticking exercise. This is another joke and a waste of money. We are not going to listen or even tell you anything that people said. And at the end of the day, the system that you prefer also on will go ahead. We assured people that whatever our failings are, the first thing that we are different from other committees is that we are actually set up by legislation. Our mandate and what we do is under legislation. Our report, although we don't take a decision on the system, allows us to give sufficient options to Parliament to make a choice. I must say, speaking personally, I was really disappointed, because I thought we could be magnanimous enough to accommodate each other and each other's views, because we had a number of choices. We can do either 3, which we have done now, or 3 up to 5, to give Parliament with that without actually separating ourselves. but it just did not work that way because either other colleagues, whatever, I'm not blaming anybody, felt that there's only one right way. There's only one right way of saying this thing. A particular view that is said about this is a problem and so on. It won't work and so on. And therefore, the law, as Minister Schreiber correctly could say, says that those that disagreement are not outvoted because you are 5. They need to be reflected. And if you reflect it, you must find a way to reflect. And the best way we found that will help committee is basically to put them in their original state, identify to the committee what they are, and then present them to the committee. But they are quite clear and they can easily be picked up. And also summarize even what we object to are things that these colleagues did not show us, but they were indeed cut out from the original report. And finally, Mr. Chairperson, I must indicate with the greatest of respect that our deadline ended on the 29th of August in terms of legislation. And we were required by the law that Minister Schreiber can give us up to 6 months extension, but 1 extension. And we asked because we thought we were moving very well and cruising, that we will do indeed finish within 3 months, which he graciously agreed to give us. And therefore, as far as some of us are concerned, we have carried out our functions. We have delivered what we were required to do and were sent to do, and we have not let down some of the people who said certain things. And indeed, we have now moved on. As I'm calling you now, I'm somewhere in Kimberley at a Mark and Bean to try and honor this. Other colleagues of mine can no longer do that because their jobs don't allow them to come in here, to come and participate in matters like this. And basically, despite the fact that Dr. Schreiber still has to dissolve us, but in terms of producing a report that can help Parliament with clear options and clear differences, that we have delivered, Chairperson, and it is before the committee, and the committee, it's his task. And I must again agree with Minister Schreiber, as he says, his now hands are tied, his functus officio. I would say without, of course, you can ask legal opinions for that yourselves. I would say, as far as where we are concerned, some of us as the panelists, I'm not talking for everybody, we have done our job. You send us, we have given you the report and clear message to the best of what we had out there. And it's now for Parliament to take the decision. There's nowhere we can take this matter any further. And we are also functus, as some of us. And we would not go back to this matter because we tried it for 15 months. It simply didn't work. And that is where we are today. But I accept fully, Mr. Chairperson, what you have said, accept fully what Minister Schreiber has said, and accept fully what other members. But the only thing that I say, I still feel this is a single report, but it has 2 versions, which make it easier for you to pick them up and be able to know the reasons why these people went into this. And those reasons, you will find them not in chapter 6 only, you will find them in the previous chapters as they go through. Even the other people, even if they say they have not made a recommendation, but you will find in the way they argue, the way they cut, the issues that they added, that finally they actually do give a preference and give reasons why they want that preference to continue to go on. So this is really not difficult. Thank you very much, Mr. Chairperson. Sorry for taking this long. I just felt I needed to say those things on behalf of what I understood as the then chairperson of this team.
Thank you, Advocate Sizani, for your comment. Well appreciated. I'm a bit taken aback by your last comment that you will not go back to this matter. And our understanding is that we are carrying a national responsibility. And it is in good spirit that Parliament has identified a collective of seasoned South Africans who appreciate the responsibility that has been given before them. So I wanted the last statement, it may not assist us, and I don't want other members of the committee or the panel to labor around that. And I think you understand us where we are,
yes,
and how we need to move forward. I'm going to invite any other member of the panel if you want to comment. Mr. Matons, can I establish how many members are here of the panel so that they can raise hands if they want to comment, then we guide this process. I see Mr. Mamabolo, Ms. Takula. Yeah, you can proceed, Mr. Mamabolo.
Chairperson, thank you very much, and greetings to the Minister and members of the Portfolio Committee. I think the starting point from my point of view is really to thank the committee and the Minister, present and past, for having provided us a unique opportunity to contribute to strengthening democracy in the country. Because the work of researching and proposing possible electoral reform go to the heart of the health of our democracy. And it's not a responsibility that I think members of the panel took lightly. It's a responsibility of great depth, of great magnitude, and the attitude that we took into the process, I think reflected that. I would ask through you, Chairperson of the committee, Honorable Chabane, that we allow Madam Advocate Takula to make an input. But before I leave the platform, Chair, it is important that we find a way of clearing out whatever difficulties there may be so that we help Parliament to exercise its mind in choosing an appropriate electoral system for the country. I think as members of the panel, we need to stand ready to work out a process to help Parliament in that regard. Because it is important that this work is brought to some kind of conclusion, and that Parliament is assisted to reach that point. And when one looks at the fundamental differences, leave the history of franchise, leave whatever, there are three options that the three reports are placing before Parliament. Of course, there are differences of approach around certain things of a technical nature, which can always be ironed out in the parliamentary process. But fundamentally, there are three options which are common three reports. Of course, the advantages and disadvantages are articulated differently, but there is that base of three options across the two reports from which Parliament can work. So I just wanted to register the fact that we need to stand ready to bring this matter to fruition, to assist Parliament to exercise its mind. But I through you, Chair, request Advocate Tlakula to take the floor.
Thank you, Advocate Tlakula. Can proceed.
Chairperson and members, good morning. And I align myself and the Minister too. Good morning to you, Honorable Minister, honorable members. I align myself with what Mr. Mamabolo has said. We must find a way of proceeding and helping Parliament. But with your kind permission, Chair, I would like to read a statement that we have prepared as the majority members of the panel, just to put the record straight from our point of view as to what led us to the point where we are, because our chairperson, Mr. Sizani, has done that on behalf of the people on what they call the minority, and to just clarify how we reached this point. So with your permission, I will just read that statement for the record. And after the establishment of the panel following its first few meetings, there was agreement on the principles against which it would measure electoral system options, as well as the structure of its report. The values and principles adopted by the panel include inclusivity, fairness, accountability, simplicity, electoral manageability, transparency, and stable and efficient government. It was agreed by all that there is no hierarchy in terms of these principles, but they are utilized to consider the various electoral options, given balanced scope and meaning of these principles, based on empirical evidence and experience. The panel also agreed as a whole that will adhere to sections 46(1)(d) and section 105(1)(d) of the Constitution as it relates to electoral systems for the National Assembly and provincial legislatures, respectively, namely the electoral system results in general in proportional representation. Tasks were allocated to panel members, and the proceedings went smoothly. Public consultations, I beg your pardon, however, took up a substantial amount of time. An extension of 3 months of its mandate was requested and granted by the Minister. Although timeframes were agreed upon for the report's completion, the timelines for submitting draft chapters were not adhered to, creating pressure to complete the report on time. With only a few weeks left before the report had to be submitted to the Minister, no report or even individual chapters had been approved. During various meetings, it became evident that different interpretations existed regarding the legal obligations of the panel in relation to recommendations. The majority of the panel members understood their task as analyzing options technically and placing all viable alternatives on the table for Parliament to consider. The impression was that a minority of the panel members sought to promote specific options. The different views manifested in two main areas. Firstly, the best way to promote accountability and the importance of overhang when a party gains more constituency seats than it is entitled to overall. During discussions, it also became clear that any choice of an electoral system could be enhanced or, in case of shortcomings, countered through ancillary legislative and administrative measures which are applicable irrespective of the electoral system. To address the diverse views, the chairperson required the draftsperson to include all perspectives in the draft chapters, allowing alternatives to be discussed and compromises to be reached during in-person meeting. Initial drafts, however, did not meet these requirements. And following protests and suggestions, panel members were assured that it would be corrected. Whether that was the case was unclear at the time, as not all the so-called final draft chapters were circulated for consideration. Instead, and the chairperson used these words, individual chapters were forwarded for copy editing, and the majority of panel members only became aware of the contents of the so-called original report after it was submitted to the minister. The only consolidated report circulated to all members for consideration was the draft majority report, which was submitted to all on the 13th and 20th August, inviting members to contribute to it. Shortly before mid-August, the final contents of the so-called original report was still unclear and had not been submitted for consideration and approval by the panel. Time was running out to meet the end of August legal deadline for submitting the report. It became apparent that the sign-off of the report could depend on whether one agreed with its content or not. The majority of the members thus approached the chairperson, who concurred that they could draft a report to resolve the difference and reflect the views of all members. Written documentation is available in this regard if needed. This consolidated report, which included all the chapters, which became the majority report, was circulated to all panel members 4 days before the in-person meeting of the panel on the 17th of August. The stated intention was that the two reports could be compared and discussed, and where compromises could not be reached, different views would be reflected in a single report. This unfortunately did not materialize, and during our in-person meeting on August 18th, we agreed that each group could develop a consolidated report and submit it to all members. However, only the final majority report was sent to all members on the agreed date of 20th August 2025. Despite initially agreeing to the majority's request for a meeting of the panel on the 28th of August 2025, the chairperson then abruptly cancelled the meeting on that day. Whilst not being circulated to all members, the second minority, or the so-called original report, was also forwarded to the minister. Members of the panel were not informed of this, nor were they provided with a copy of the letter sent to the minister. When the documents were made publicly available, the majority of the panel members wrote to the minister on the 23rd September outlining this. The minister responded on the 10th October that having submitted the reports to Parliament, his view was functus officio. So that is what happened, Chairperson, from our perspective. Thank you very much, Honorable Chairperson and members.
Thank you very much, Advocate Lakula. I see the hand of Michael. It's not written properly on there. Can you proceed?
Thank you very much, Chair. And mine is very short and simple. Oh, yeah. I'm part of that group of five. I just felt it's very important to thank the committee, but particularly also Parliament for appointing me to this. It was a great learning experience, certainly, and given my my history and demarcation in particular, it was very useful to look at the three options as Syed indicated. Secondly, I simply want to endorse the statement that we had prepared here. And then thirdly, just to say, certainly personally, I can't speak on behalf of anyone else. We're very happy, and I'm very happy if there's any assistance that the Portfolio Committee requires, certainly at no cost, on exploring any of the issues raised there. Our intention was to provide as technical a report as we could. But thank you again for this opportunity. Appreciate it.
Thank you very much, members. And thanks, Advocate Sizani and Mr. Mamabolo and Advocate Tlhakula. And our last...
I'm very sorry. I'm using a different gadget. I don't know where I raised my hand. I'm a member of the panel. My name is Matsia. I don't know if you will allow me to speak as well.
Oh, okay. You did not, as indicated, the challenges. You can proceed to comment. You're a member of the panel.
I am a member. I do apologize. I'm using a different gadget. I've been trying to check where the hand is. I'm very sorry, Chairperson.
No. You're welcome. Proceed, ma'am.
Okay. Thank you very much, Chairperson. I would like to acknowledge you and the committee and the minister and the deputy minister. And I am one of the members who is part of what is called the original report. And there's just a few issues that I wanted to clear, at least from my side, especially what happened on the meeting of the 18th. I have noted the advice that we've been given by this committee in terms of trying to make the work of Parliament easy. And I would like to believe, I don't know if we can have a way forward. Chairperson, shortly before the meeting of the 18th, on my email, I received a copy of the report that says herein is the report while we were still busy with the chapters. There was a process that was agreed on. Obviously, any process would have its own challenges in terms of how do we write the final report. That will start chapter by chapter, and then it will circulate, and the inputs will be considered, will be debated, and then we can agree. So there was a back and forth in terms of, if we have 9 people, some people will feel passionate about the other issues and other people will feel passionate about the other people. So there was this issue that in certain chapters, and I think it was chapter 2 and chapter 3, that some members' inputs were not actually consolidated, despite the fact that they've been indicating over and over again that they need to be added, right? That was how I know the process. Now, when I see this report, as an individual, I didn't know where it comes from. It was circulated by one of the panel members to say, here is the draft reports for your inputs. And then I asked myself, okay, I thought we were meeting on the 18th to discuss a chapter on options that are there. We've been talking about these options for a very long time, and I would like to agree with Advocate Pensi Tlhakula that from the beginning, that has been the case. So the first question that I asked but why now are we having this report? And I'm listening to the presentation that the chairperson has agreed that 4 people or whatever number of panel members would write that report. So when we met, on the 18th. It was a Sunday, and actually we were struggling to get dates where we can finalize this, and then we agreed that we'll meet Sunday and on Monday. So I saw the report, I noted it. I did ask one panel member, like, where is this report coming from? But I didn't know where it came from. I didn't know whether the chairperson authorized it or not. And on the 18th, there was a very long debate. I think our meetings are recorded. We have audio recording, we have minutes, but I don't want to belabor the point. But the question that we asked was, where is this report coming from? And we were told that the chairperson had said sitting people should write a report. So there was a debate between the chairperson and other members. The chairperson said, no, you were supposed to look at the chapters where you believe your inputs were not considered so that it could be put to rest, because the issue was that the drafter and Professor Ndlelana, who was the person who was writing, didn't consolidate those fees. But there was a disagreement even between the chairperson and these members that, no, this is not what you said. There was like a very long debate. People saying, this is the WhatsApp that I got. Unfortunately, some of us were not part of that, right? Personally, in trying to get a way forward, I said, I do understand that you have presented a report that obviously will have all the chapters and you want the inputs, but we are not sure. I personally was not sure that in terms of this report, what was taken out, what was added, because it was just a report without track changes. And I'm like, if we have been doing draft chapters and we're taking them back and forth, and certain things obviously are not sitting well with you, you will have track changes to say this one were removed because of A, B, and C, so that even the authors or the sponsors of those items would know. So I said, yes, I do get that, we're not finding one another. Maybe this is what we need to do. Can we project the document, the chapter that we've been dealing with, and can we check where the changes could be? But we couldn't agree, Chairperson. We just couldn't agree. And then eventually there was an agreement that because we can't find one another, I think we've displayed few slides.
Check.
And on those slides,
3, 4.
there was no agreement on the way forward. That yes, this one we remove, this one, we put, and so forth and so on. So on that Sunday, we agreed that we will go separate ways. People will see which inputs they want to make and on which. And this is, I'm trying to figure out at what stage and when and using what platform did the chairperson, because I believe I'm also a member of the committee. So if there's a change in the process, at least I would like to be informed. But it seems like there were people who were speaking wherever they were speaking, whether on WhatsApp, whether on email, or some people were even called, can you please come and meet? Some of us were never part of those discussions. So I wanted to figure out if initially we have agreed on the process, that this is how the process is going to be, but we also understand that we're different people with strong views elsewhere that we cannot agree. If there's a need to change the process, why are we not sitting together as a panel to say that this is where we are, this is the new process that we are taking forward? And that's where I was confused on that Sunday, that there are people arguing, there are people not agreeing, there are people who have WhatsApp chat, there are people who have been called, there are people who sat elsewhere and drafted what was now presented as the report. That's how I came to know about that report. And I felt Personally, I was excluded from the entire process because I don't know what was happening. I don't know how many of us knew, but I know that there were people who were calling each other to say we need to meet because we need to prepare a report. But all I'm saying is that I would have understood if there was a meeting or there was an email which says that this is where we are. We need to meet because we need to change the process and come up with an alternative process. That was never done. That is my submission, Chairperson. Thank you very much. And apologies again for just speaking while you were still speaking.
Oh, no. We afforded all members of the panel. You don't need to apologize. We respect all the team. And it's important that we note the difficulties on your gadgets. Now, let me propose how we'll handle this matter, members. And we're following up on the comments of members of the committee and the reflections of the panel that is chaired by Advocate Sizani. We have now noted and will advise that we don't move further on the comment around this subject so that we don't get into, it is clear in our opening that we have outlined, ministers commented, members have commented, we've given opportunity for the panel to do that. And the exercise, it was to make sure that we tighten all the processes and the credibility of your work into a phase that Parliament or the committee must now engage on. And that is our objective around that. And issues that were not differences in terms of formulation of chapters, views were carried by members of the public, is ought to happen in the discourse of developing a report or any legislation. It does happen in the committee when we debate, deliberate on this or the other. But process is important at all times. We'll request two things. One is that the statement that has been read by Advocate Tlakula should also be sent to the committee, including the statement that has been made by Advocate Sizani. We've recorded also the members' comments of the committee, of the panel, in relation to how you are navigated the process. Secondly, we'll then engage with the parliamentary legal services. They are here in the meeting. We've already cautioned when we're going through the report on how we must move forward within the time frame Parliament and what is guiding us in the legislation. So we're going to engage with the parliamentary legal services. The intention is that we must have a report that is reflective of the members of the public. And there's no, in this process, which I can make members recollect, this process of appointing the panel to look on the electoral reform, it was informed by the public submissions from various stakeholders. And Parliament ought to consider the views carried by members and pass that decision to appoint, so that the work that has been detailed is before you. So that is the third point I want us to consider. It is clear from our side that there are challenges around that. I'm happy that all of you have taken this national responsibility, noting that it's an important report once a piece of legislation being carried, that it will resound within members of society and stakeholders. It's a call from members of the public that we may need to look 30 years into democracy, evaluate the current system, and give options on what may be the new course of the electoral system. And I'm happy that members of the committee are raising the matter of the Independent Electoral Commission, that at all times bills are delayed in order to impact on the work of the IEC when they facilitate the elections, either in the next elections or the other elections. And we must be cautious on the time frame and the outline of the program of how Parliament works. So the Parliament committee does not sit with one item, with a pile of process of legislation that we might need to take moving forward. So I wanted us members to consider that we then convene the Parliamentary Legal Services, engage on this matter, engage the Speaker around what we have now received from the Minister, the report that has been presented. Ourselves and the Minister, the committee, will agree, and we've noted that it's unfortunate how the process was undertaken. We have not entered into dealing with the details of the report, and the committee is not rejecting those reports. We're cautious on the process so that we avoid Parliament to enter into litigations in terms of the process that will be taken. Honorable Mkhali raised an important matter that if the committee wants to subject the process, the public give a view that Parliament may need to consider in relation to the minority, as you call it yourself, or the majority view, we may seem to put Parliament into a corner. It is clear that Advocate, Chairperson of the committee of the panel, ought to present a single report. It would be difficult for the Chairperson to present the report that he, in terms of the his remark, is not gone into detail. So it's important that we have a responsibility to assist in managing the process that must be undertaken by Parliament. So we'll take that route, that will stand off this item, and we engage with the Minister and in terms of the time frame that we may need to allow the process to be engaged on, and we'll come back to the panel once the legal team has met with the portfolio committee and on how far we must proceed on this subject matter. I raised deliberately the last matter. Can we mute? Because we have been disrupted.
Sorry, Chairperson, can I ask, please, for just privilege, just to put on record 2 points, not it won't be half a minute.
Advocate,
they are reflecting to me personally. Yes, Chairperson. Yes, Chairperson.
In the committee, we're not running meetings like that. With due respect, we're not members of the committee are not running the meeting like that. This is a committee of Parliament. So we'll meet with the legal team, get a report, details on what is being raised in this meeting. we appreciate all the matters have been raised by you members of the collective. All of you who have spoken and give a report, because we ought collectively to assist each other in order to respond to the questions that Parliament and members of the public has assigned us to do. So we've requested that you ought to do that representation, Advocate Sizani and Advocate Tlakula, on the issues that have been indicated. Can I get a sense from members then if there's any other matter? I see Advocate want to raise, but can I get members first on the proposal that we're outlining? Members? Honorable Mukhala?
No, thank you very much, Honorable Chair. I think the way forward that you have presented is acceptable, Chair. Let's get the input of the Parliamentary Legal Services with regard to how best we should approach these issues. But it's quite unfortunate, Chair, that we had a panel that we had complete confidence in to do a proper job in this regard. And now that we are here, Chair, it's very sad. It's quite unfortunate, really. However, Chair, support the way forward that you've presented before us. Thank you.
Thank you, Honorable Mkhale. Honorable Ngubane.
Chair, I concur as well with your way forward. It's critical, Chair, that we get input from all views of the panel, so that when we make our decision and advised by the legal advice from the Parliament, we stand on the point that we know whether the difference really that they had, it would have assisted us as a committee to ascertain how do we move forward from here onwards. I think that way forward you've given, Chair, of having all those members of the panel who have spoken to put all their to give all their input in writing, it will really assist us in moving forward. Thank you very much, Chair, for the way forward.
Thank you, Honorable Ross.
Thank you, Chair. Chair, I certainly support the way forward. And again, I think there's two reports that have a lot of information, plenty of information for us to be able to adjudicate. So I think it's really to get that clarity from legal as to whether we can proceed or not and how we proceed. So we fully support the proposed way forward. Thank you.
Thank you, Honorable Ross. Honorable Disemte.
Thank you, Chair. I think we are also in support of the way forward that you have proposed. But just to check as well, Chair, that will both reports be interrogated by the committee, given, of course, the pending legal opinion or advice that we'll get from the parliamentary services, but also for them to be able to advise us if both reports are legitimate or are eligible, that the members of the committee can be able to interrogate, or that a one consolidated report may need to be considered. Thank you, Chair.
Thank you very much, members. You have commented. I'll go back to Advocate Sizani and Advocate Tlakula. Chairperson Sizani. Advocate Sizani, you wanted to make a comment? Advocate Sizani? Advocate Sizani? Okay, can I invite Advocate Tlakula?
Yes, thank you, Honorable Chair. All what I wanted to say was that the statement that I have read is included in the presentation that we submitted to the Secretary of Parliament, of the Portfolio Committee.
Yes,
it's already there. Thank you. Thank you, Chair.
I just wanted to be on record. Can I check if Advocate Sizani is in the meeting, Mr. Matonzi? We had wanted to raise a matter?
I just checked now, it's not in the meeting.
Okay. I see the hand of Honorable Mlebohe Mutise. Mtsa, is there a legacy hand?
It's a legacy hand, Chair. Thank you.
Okay. Thank you, members. With our resolve, I think, has been clear to chair of the panel before he got out of the meeting. Already we have put how we must move, and the team and members of the committee will then, Mr. Matonzi, facilitate a session with the parliamentary legal team urgently, and interface with the speaker on how we ought to deal with this matter. We'll come back to the committee with the legal team to give a perspective on the two reports on how we must move forward with there's an important question on December, but we'll await the legal team of Parliament, and then we'll deal with the framework in terms of the time frame for public comments and the full briefing from the panel on the issues that have been raised. I must thank all of you, members of the panel, Advocate Sizani, the chair, and all members of the panel for having contributed on this subject matter, and also enriching the process that the Parliament or Portfolio Committee needs to take moving forward. We'll come back to the committee through the Minister of Home Affairs in relation to the interaction and scheduling for full briefing for this subject matter. By our time frame, if Mr. Matonsi can able to engage with the Parliamentary Legal Service, the chair and the team, and next week, so that we brief the committee and afford the Parliamentary Service to brief the committee. Therefore, we take a process to invite the minister and the panel to our session again. Thank you. We're now releasing you, all members of the panel, to engage on the last item of the committee meeting. Thank you.
Thank you, Chairperson. Thank you, members.
Can we now move to...
Thank you.
In our last meeting, we dealt with this report. There were just areas of cleaning up the report. Members commented. We agree that today we'll only adopt once Mr. Salmon has dealt with where we're supposed to clear up the report. Can we then move to issues that were supposed to be cleared up, Mr. Adams, and consider the report?
Thank you, Chairperson. Yes, the main recommendation really was just to ensure that the recommendations that were outstanding from previous years were actually directly imported into the recommendations section at the end. And I've now done that. There are a lot of them, 44 in total, but rather than going through them, I did submit this to members on Tuesday already. I don't know if you want me to read through all the recommendations, or if we just, if we're okay to just go on members having read that the recommendations are in fact what they want. I take your guidance, Chair, as to whether I should go through all 44 of the recommendations, or
no. Is it that, Mr. Adams, in our meeting on Tuesday, we went through the report. There were only areas where you're supposed to correct. You recall there was a proposal that there are issues that were carried by Legal's report.
Yes.
Just to highlight, and because the document is a public document, so it must. The proposal that was carried by Honorable Ross in our last meeting. Then we don't need to read all, because we've went through the document, we've deliberated on it, and there were issues that need to be inputted. Thank you.
Yes, thank you, Chair. Yes, I've done that. And as indicated now, there are a total of 44 recommendations organized by entity. And I've done as indicated, including the matter that the chairperson raised on issues of CETA. They are also captured here, both in previous year's recommendations and updated for now. So I've done as indicated. So it's up to members to adopt unless they have further questions. Thank you, Chair.
Okay, thanks, Mr. Salmon. Members, is there any comment on the report? If there's no comment, can I invite hands for adoption?
Chairperson.
Honorable Manchi?
Yes, thank you, Chairperson. I rise for the adoption. Thank you.
Thank you. Any seconder?
Chairperson, I second. Honorable Ruiz.
Thank you, Honorable Ruiz. So seconder. Any objection? Thank you. The BRRR report has been carried with recommendations that reflects our interactions with all the entities and the Auditor General and all the decisions the committee has taken to make sure that we track the process of this report. We'll now stand off this item. Is there any item, Mr. Matonzi?
Okay, that was the last item.
Chair, if I can also just indicate that in terms of your recommendations of having a record tracking of outstanding recommendations and issues of the committee, I've set this up and I'm communicating with the department to make sure that they keep this record updated with outstanding issues, and I'll share that online spreadsheet with members as soon as we have that process formalized with the department. Thank you, Chair.
Okay. Members, this public hearings and the debate, the report of the IEC candidates, that must be tabled next week on Tuesday in the House. And we are scheduled to be in the public hearings. It's from Monday, Mr. Matonsi, if I'm correct.
Yes, Chairperson. No, I think we are going to be in Neisner on Tuesday, but we're leaving on Monday, and then the 28th will be on Wednesday. And then we are going to be in Worcester, but also there's that debate on the IEC commissioner, I think at 2 o'clock.
On Tuesday?
No, on the 28th, which is Wednesday.
No, it can be Wednesday. There's a debate on the report that must present Parliament on Tuesday at 2 o'clock. Unless it has been changed to Wednesday. The notes we've received yesterday, I received yesterday. I know Wednesday is either cluster oral questions or is Deputy President or President response, one of the two. Can you guide members on how, or can firstly guide how you think we must deal with this matter, Mr. Matonsi, before I invite members to comment?
I know that is going to be on the, you said the message that I got from you is going to be on the 28th. So, because the sitting on the 28th will be hybrid. So it means that there could be members that are needed to be in person in Parliament, and then maybe the other members can just proceed to the public hearings that are in Worcester, because we can't cancel at the last stage.
Mr. Matons, when is the 28th, the day?
Okay, I'm just checking here, Chair. Let me just check on my calendar.
It's not Tuesday.
It's Tuesday the 28th. Yes.
Okay.
Yeah.
Members, can I invite for comment on this matter? Honorable Makhala?
Yeah, thank you, Chair. Firstly, Chair, I don't know. You called for, before that report was ATC'd, for us to make certain changes. And there were areas that I had also indicated that were not incorporated into that report. So I don't know, Chair, what happened. Maybe the team there can explain why some of the inputs that were supposed to have been incorporated, that we agreed on in the committee, that they should be reflected, were not incorporated into that report. So I just wanted clarity on that, Chair, because when I saw that they are even commented on our platform to say, but some of the issues that we agreed that they should be incorporated, they're not there. So I just want an understanding as to what happened in that regard.
Okay, thank you, Honorable Ross. With that point, can also members assist us to navigate this matter of the public hearing and see where will assist both the report and also the public hearing to proceed, because public hearing already has gone into preparation. Honorable Ross.
Thank you, Chair. Chair, yeah, it is a Tuesday, and the plenary is supposed to be from 2 till 5, the last time I checked. So it is hybrid. I don't know if it's possible to influence the desk to make that debate the last one of the day, so that it may start after 4. But even then, to travel from Worcester back would be an hour, hour and a half. So it's going to be quite tight. But perhaps then if we don't make it physically, then we would be able to do our presentations virtually. Thank you, Chair.
Thank you very much. Mr. Maton, do you want to comment on this public hearing? I'll come back to the matters. I want to also raise something on the report, on the proposal of Honorable Ross.
Yeah, Chairperson, yeah, I think that could make sense if, as long as when we were there, we are able to leave on time for members to be able to attend at least by 4 o'clock. Because it's an hour and 30 minutes drive from Worcester to Cape Town.
So the public hearing only starts on Tuesday?
No, the public hearing, they start on the 27th in Neisner.
Oh, it starts on
in Neisner. And then on the 28th is Worcester. So that's when the debate is scheduled.
Oh, I see.
Yeah.
Okay. So the options members may take is those that want to do hybrid and we can consider that. And normally the report is present, the chairperson must be in plenary. The other option we can consider is to proceed with the public hearing and members join the plenary on Tuesday. They can fly from George to Cape Town for purpose of Tuesday plenary and join members on Wednesday. It's a complicated matter, but we may need to see how we navigate that process. So let me leave it to members to see how we can navigate, but explore this matter of changing the items to be the last item. But also, if you change the item to the last item, members are still traveling. to where they must be comfortable, or the public hearings drags until 2 o'clock, you still have to travel to a destination of your accommodation. It may be a cumbersome issue to deal with that. I will propose that let's look at differently, but we'll work that option. If members get attend, we can attend public hearing on Monday, and after that, members, those that are going to participate, fly to, or those that are needed in physical, fly to Cape Town, and members remain with the public hearing on Tuesday, so that we give enough time for those that want to participate, or those that are going to participate, particularly from this committee, to make sure that to miss one public hearing and we join the last public hearing. Obviously, it will be in Cape Town. Yeah, I think that it can assist us. I'm not sure, members, if you can guide around that so that you can look at it with Arense, and it's another option, and Matonsi on how we must deal with that. The matter, okay, Honorable Ross, you want to deal with this one?
Thank you, Chair. Chair, we have done it before, where you've had to go for various reasons, or some have had to go, for example, with the chief. So that's also another possibility, is to say that there would be a van going a bit earlier, and then as many members as possible stay later. And some can decide they will do it virtually. And then we make sure that there's enough persons remaining at the hearing, and then the second transport travels. Because according to the schedule, we're going back to our villages, essentially after the Worcester hearings.
Okay.
So maybe that's a way that one set of transport goes, and then others. But it's something we would also have to discuss offline. Who would be willing and able to do it online?
Okay.
So then we have two separate. One van leaving earlier so that certain persons can be there physically at the beginning. But I think the important thing as well is to try and make it the last item.
Okay. Let's take that option, Honorable Martin.
Thank you, Chairperson. Firstly, I would like to know, when are we going to fly to the place where we will start? Because if we're starting on Monday, we can't be there on time. The other thing is, on the 28th, which is Tuesday, myself, I would like to be in Parliament physically in the sitting when the report is being tabled. So now I will request that maybe if we can get the transport arranged for those who will be supposed to be there physically, like myself.
Okay, noted. Disemza.
Thank you very much, Chair. I think the option that Honorable Rose attempted to make me work, I think yourself as a chair, you can do the opening of the public hearings and then leave early on time to make it for a debate, because as well you will need to be the one that presents the report of the committee in Parliament physically. Therefore, including one or two members, Honorable March has already indicated that herself representing her political party as well, she would want to be in the House. And then we can have the rest of the members remaining to continue with the public hearings, and others then can be able to take up their debates or presentations on a hybrid option. They can then indicate to their chief whips that they will be participating in public hearings, therefore they will do hybrid, as long as the chair is able to then leave on time so that he presents the
the report in Parliament, including 1 or 2 members who feel strongly that they would also need to be physically in the House. And also I support that our secretary should inform programming committee or the ones that are doing the orders of the day that Home Affairs is having public hearings on that day. Therefore, we request that the item be the last one. Thank you, Chair.
Thank you, members. I think let's engage with the programming and Mr. Matonsi and Arense on the logistic of our work. The good thing is that at least ourselves as a collective, we can facilitate the public hearings. And I think we've established that collective work. If those who are not going to participate, even those that want to participate, but in particular, those that are not going to participate, they can facilitate the public hearing. I'm raising this if there's going to be a challenge of also shifting the time, the programming, shifting the slot, but let's work around that on all frameworks. But the point now that we agree that public hearing will proceed, it will be hybrid, and those that want to be physical, at least we must know early and how we need to compromise on the process. I think let's carry it like that. The last point Ora Mohale raised, I've not seen.
Sorry, Chairperson, I've not answered about when are we leaving from our constituencies or where we're staying.
Okay, can I get the team to brief quickly?
Chairperson, the members and everybody were leaving on the 26th, flying into George, and then sleeping there, have public hearings in Neisner on the 27th. After the public hearing, and then we fly back to Cape Town, and then from the airport, and then we proceed straight to Worcester.
So we'll leave on Sunday to George?
Yeah, to George. We take a flight to George, flights to George.
Okay. And members have already received their traveling arrangement?
I think Thurston has done that or is doing that. I'm not sure. I'm sure it's not, it could be in the meeting now. He was working on that so that members, they get their tickets.
Okay. Honorable Martin, is that fine?
Yes, thank you, Chairperson. So we'll wait for the tickets. Thank you.
Okay, thanks very much. The matter of the report, Honorable Mohale, I want to get into, though it has been 80 seats already, because we're dealing with the summary of the reports. Where is the issue you wanted it to reflect on the report? Around or let me put around all the recommendation of the Chief Justice.
No, Chair. What we agreed in the committee on Tuesday was that the issues are highlighted by members of the committee, including the panel, on some of the candidates, will also be reflected on the report. That was the issue, Chair.
Oh, okay.
That it should reflect that we were unanimous on this particular candidate. However, on this other two candidates, this is the feeling of the committee.
Okay, if I think it was not dealt in words, but if I check I'm checking okay, I've read it. There's an indication there that there was a unanimity on the candidate one first candidate and the two candidates were subjected to voting. And the understanding is that members of the committee will then, in terms of where we're summarizing the report, will carry the debates on the reasoning why they don't support these other candidates, why you voted. And that is an understanding of the summary of the 80 seat. But it's clear that on one candidate, it's in that report. I'm sure if I'm reading a wrong report that is on the report. Mr. Matons, can you come in?
Yes, Chairperson. Yeah, you correctly put it that with regard to Mrs. Pizzo, there was unanimous in terms of the support, but the two other candidates, that is Judge Pillay and Mr. Muyepia, they were subjected to a vote. So what Mr. Mkhale is raising was the reason why probably he did not support, or other members did not support the same candidates. But I'm thinking that, as you correctly put it, this can be used as a debate in the House on Tuesday to say, probably, let's say, particular party did not support this candidate. These are the reasons that they did not support, instead of putting all those reasons in the report, Chair.
Yeah, that's the framework of how we summarize the ATC and the issues that we carried. Other reports, they don't go into details that there was anonymity, people went to, members went to votes, and this and that. That's the reason that we must explain when we make our submissions in terms of the quality of decision we have taken. Okay. Thank you, members. We will, not members, Mr. Matons, I request that you call, you arrange a session with the legal team, but give them a brief, at least by Monday. We must able to interface, I must able to interface with them. I know I will be in the public hearing, but it's a 30 minutes on Monday. If we can have a brief virtual at 7:30 on Monday before we proceed to the public hearing. Is there any other matter, members?
Yes, Chair. Thanks very much, Chair. No, Chair, I just wanted to highlight something that is of concern to us. On two occasions, Chairperson, during by-elections, we have taken people to the Home Affairs to do temporary IDs. And it has been a very frustrating experience for us. It happened in Polokwane, it happened in Soweto, 29. So it's just something that I wanted to bring to attention, that it's very frustrating to take members of the public who want to do their temporary IDs, which entitle them to vote, and they are frustrated or they are denied by some of the officials at these IEC offices. I think I did even send you a message to that effect. Thank you, Chair.
And I think it's not the first time, Honorable Mkhale, in Mpumalanga, I was called one by-election there. They were complaining about the same thing of Home Affairs not responding to assist members of the public with temporary IDs, but also raising the closing time of Home Affairs on the days of by-elections. Home Affairs close early and IEC voting close late. And if a person in the space want a temporary IDs, they are unable to get to that. We'll take more attention to that and engage with raise the matter with the DG immediately, and I think when we meet next week, we'll have a result. But I want also to Mr. Matonsi, Mr. Adams, to assist members on the complaints that we raise immediately. The PLO of the department, the PLOs of minister and deputy minister, part of the reason they sit in the committee or interact with members of the committee is to assist members of the committee to resolve issues that are raised by members of the public. It is not good that when a member of the committee has a problem, they must raise it with the chair in order to get a resolve. All of us here were equal as members with a responsibility given by the Constitution. So we can't frustrate members of the committee. Every time they want to interact with Home Affairs, there's an issue. They must send the chair to respond. The department, the parliamentary liaison officer must know that if I call him or her, I'm a member of the committee or any member of parliament or a council who are representing or a public representative, there must be an urgent matter to resolve. Like this matter of the temporary IDs on this voting. If you have 20 people want temporary IDs or 1 or 2, that person who should understand that she or he has a right to participate in electoral reform. So I would request that Mr. Matonzi and Mr. Adams, you engage with the parliamentary liaison officer of both, Dr. Schreiber, and Mr. Deputy Minister Njabulo. I'll also talk to the Director General around these concerns of members are raising. Honorable Mohammed always sent me, get frustrated on spot. He said Home Affairs Office, she get frustrated by our officials. And so I don't think that's the spirit in which Home Affairs need to treat public representative. Public representative, they don't have, members of the public, they don't have a way to raise their issues. They rely on the public reps, councillors, members of the provincial legislature, and members of parliament. So I think we must rework that spirit in line with what we've decided of tracking our work as the committee. Thanks very much for those issues. Thanks, members. And I want to appreciate we've dealt with a difficult matter, but I think we'll get a resolve so that we are able to move forward. The meeting stand adjourned.
Thank you, Chair. Thank you, Chairperson. Thanks.
Thanks, Chair. Thanks, Chair. Bye-bye, members.
Bye.